Good afternoon, everybody. This is the SIIA's webcast, Copyright for Publishers. We are live in New York at the McGraw-Hill offices, and we'll be having a frank and plain English discussion about copyright and the anti-piracy agenda impacting your company and bottom line. Thank you for joining us. This is Kathy Greenler-Sexton from the SIIA Content Division. And for those of you who may or may not know us, the SIIA stands for the Software and Information Industry Association. And we are the premier trade association for the software and information industry. And what we do is advocate and protect on behalf of our members in terms of government affairs and anti-piracy, and through our many divisions focused on the industries that you see here, we work to educate and support business development and other goals that our members have. Today is one of the many events that we have. This has been put together by our Copyright and Licensing Working Group from the Content Division, and you can see a few other webcasts as well as in-person events coming up over the next month. At the end of today's event, I'll go over the full calendar for those who might be interested. So today we have Keith Cooper-Schmid, who's our General Counsel and SVP of Intellectual Property Policy Enforcement at the SIIA, and Dan Duncan, Senior Director of Government Affairs at the McGraw-Hill Companies. And again, this is Kathy Greenler-Sexton. I've chosen to stay off camera so we can focus on the two of you today. So Keith and Dan, take it away.
Okay, thank you very much, Kathy.
Thanks, Kathy.
So what we've done here, Dan and I have done, is try to identify really what we thought were the top 5 policy issues that will affect the content industry and content business generally. And hopefully we've gotten that right, and hopefully as the name of the webcast discusses, we can put this in plain English for everybody. And so I'm going to start off by talking about really the first of these issues, which is market segmentation. The issue, that issue of market segmentation, let me talk about what I mean by that. What I'm talking about is the ability of copyright owners to treat different markets as they should be, which is to treat different markets differently. By doing that, there are a bunch of benefits not only to the copyright owners and the content industry, but also to the underlying consumers, the people who are buying your products and services. Copyright owners are able to make their works more widely available. They are able to make their works more affordable. You can make different products for different geographies, and therefore you could market a book perhaps at a lower price, for instance, in Thailand, and you'll understand in a minute why I'm picking Thailand, but you could sell a book in Thailand for a lesser amount than you could sell, for instance, in the United States, because if you had to sell it at that same price in Thailand, the people there could not afford it, perhaps. There are other reasons, cultural differences. There may be items in that book, in that content, the newsletter, whatever type of content we're talking about, that need to be presented a little bit differently in one country as opposed to another country. And those cultural differences need to be considered. That's another reason to sort of be able to segment markets, comply with local laws. Defamation law may differ, for instance, from one country to the next. Privacy law may differ from one country to the next. Copyright law may change and differ from one country to the next, as well as many other laws. And so you want to be able to tailor your products, if you can, to different geographical areas. And that's all possible by virtue of this market segmentation. Well, under the copyright law, this market segmentation is accomplished through what's called the first sale doctrine. Now, at SIIA, we have not only content companies, but also software companies. And as you might imagine, they don't necessarily always see eye to eye. This issue, the first sale issue, which sort of has 2 sub-issues, which I'll talk about, that's one area where they absolutely see eye to eye. That our software companies, our content companies, really all of our membership see this as a very, very important issue and one that really does present a significant threat to their industry. So let me talk about what I'm talking about when I say the first sale defense or the first sale doctrine. The first sale doctrine is a provision in copyright law that allows you to basically, once you buy a work, buy some copyrighted work, it allows you to then dispose of that work as you like. For instance, you could take that work and you can throw it away in the garbage. You could light it on fire, you could give it to a friend, you could sell it at a garage sale. Okay? You can't make a copy of it because that would implicate a different copyright right, but you can dispose of it or distribute that work as you see fit. Okay? And so that's the first sale doctrine. So why am I raising this? Well, the first sale doctrine is what makes market segmentation of copyrighted works possible. It is what allows you to control the distribution of your work in different countries and make sure, for instance, that work in Thailand doesn't come back into the United States. Okay? So let me now talk about the Kurtzing case, Kurtzing versus John Wiley. This is a Supreme Court case that is pending right now. We expect a decision really within the next 3 months, but certainly by the end of June, we will get a decision in this case. And what happened in this case, you have Mr. Kurtzing, who is now Dr. Kurtzing. He was a student at Cornell University. And what he did was got a lot of his friends and families to buy books. He's originally from Thailand. To buy books in Thailand and then ship them to him here in the United States, where he would sell them on eBay. And because those books were sold in Thailand for a fraction of the cost of what they're sold in the United States, he was able to make a significant amount of money. Reports are $1.2 million or around that range is what he was able to make. So we're talking about big dollars here, okay?
And if I could just, so one of the reasons market segmentation is very important is because of pricing differences. Many of us have to price lower in a foreign market in order to be able to sell goods in a foreign market. So that really is one of the big issues that you'll see comes up in this case.
Yeah, Dan's exactly right. And so what happened is John Wiley, as well as other publishers, didn't exactly care for what Mr. Kurtzing was doing and decided to sue him. And they prevailed. They prevailed in the court. And the courts basically said if the books are made in Thailand and sold in Thailand, under the copyright law first sale doctrine, they need to stay in Thailand. They cannot be imported into the United States. Okay? And that's what the court said. The law itself, the first sale doctrine, isn't crystal clear in this area. The statutory language is not so clear. And so Dr. Kurtzing has now appealed, gone all the way to the Supreme Court to test his case. But so far, the lower courts have found him liable. The arguments have been made in front of the Supreme Court that this type of activity, market segmentation, is essential, is crucial for copyright owners in the copyright industry, and therefore the first sale doctrine ought to apply, first sale doctrine ought to not apply, and thereby allow copyright owners to control the distribution of their works. And so that is, in a nutshell, is the Kurtzing case. There's another issue regarding the first sale doctrine, which is an issue that more deals with licensing. Okay, and as I mentioned, this is the first sale doctrine, so it deals with sale of goods. Where those goods are licensed, there is no sale, and therefore the first sale doctrine would not apply at all. There's factions back in Washington, D.C. that are pushing for the first sale doctrine to be changed by Congress, to make it so it applies to what's called a digital first sale doctrine. So it would apply to digital goods that are licensed as well as sold. As you can imagine, that's a significant issue for not only software companies, but content companies as well, because as more and more content companies move their products, if they're not digital already, they will be, certainly in the future, and those digital products are going to be subject to a license almost assuredly. And so they will not be sold. And you want to have your licensing terms to be enforced. So if you say, look, I don't want my work, my copyrighted content to be transferred to another party, then you ought to be able to, that license ought to be enforceable. You ought to be able to enforce that license to prevent somebody from transferring that work. This issue has come up outside the United States. It's come up in the European Union, where unfortunately the court looked beyond the license and said, even though you're licensing the work, this is really a sale anyway, and what that meant was, even though the software was licensed in the case I'm talking about, and the license said you could not transfer the work, the court allowed the user, the consumer, to go ahead and transfer it anyway. In the United States, there are several cases out in California where the court has very clearly held that the first sale doctrine does not apply where there is a license in effect. And the license is clear on its face that it is a license. And so this is a very, very large, very, very big issue, because you can imagine things like, certainly in the software industry, software companies distribute their software, for instance, academic software as an example, to students and to teachers. If all of a sudden those students could take that software, which is sold to them at a lower price, and then resell it on eBay for a much higher price, make a lot of money doing it, that would really eat into the market, the market that the software company is trying to sell to non-academic, non-students, non-teachers. And so that would present a significant problem.
Well, there's also a very practical business problem here, and that is, going back to what Keith said earlier, in first sale doctrine in terms of hard copy goods, you can dispose of the good however you want once you've bought it, as long as you don't retain a copy. And the problem with the digital first sale in terms of practical business solutions is you're going to have to find a way to make sure that whoever wants to forward that on doesn't therefore retain a copy for themselves. You're going to have to put maybe a time bomb in there, which we don't like to do in terms of customer relationships, but you're going to have to somehow be able to police the fact that the original user of the licensed, therefore rented copy doesn't retain that copy and continue to use it after that person forwards it on to somebody else for their purposes. And I think that's really what we have to start thinking about in terms of some of these copyright law changes, is what's going to be the practical business effect, how it's going to affect your relationships with your customers, and how you're going to find a way to continue doing business in terms of digital publishing without having a big hole in the law that allows people to take your copies and recopy them to everybody else in the world.
Just a quick question. Do the courts really understand the business pragmatic issues? And I'm just curious what your understanding is as these cases move through the courts.
So just to repeat the question, it was, do the courts understand the pragmatic issues, the practical issues? And I guess the best answer is we'll find out. The Supreme Court will issue its ruling. I know the courts handling the software cases out in California absolutely did. They said as much in their decision. And in the New York court that handled the John Wiley case as well understood the practical and the pragmatic aspects of these cases. What the Supreme Court does, that remains to be seen. And even if they do, the Supreme Court really has to look at what the law says. What does the law say? Now, if it's ambiguous, then they might, gives them a little bit of wiggle room. But there's a lot of people out there, polling to see, okay, where do you think this will come out? Do you think it will come out on the side of the publisher, or do you think it will come out, this case will come out on the side of the user, the consumer here, the person who is selling, Kurtzing? And it's really split. I mean, there was a very similar case that was handled by the court a couple of years ago involving a copyrighted design on the back of a watch. In that case, it was one justice who was recused, in other words, could not vote. And in that case, it was a 4-4 tie. So even the justices seem to be fairly split on the issue. This case factually is a much better case than that watch case was, certainly.
But I think we anticipate that regardless of what the court says, there's going to be an effort in Congress to reverse whatever the court says. So if the court comes out on the side of publishers, then the other side will go in and demand legislation to clarify, in their words, and I would say the publishers will probably be doing the same thing. If the court comes down on the side of Kurtzing in this case, publishers are going to need some sort of legislative relief to make sure things don't get out of hand.
I mean, I think just to revisit one of the issues that Dad mentioned, he talked about the importance of policing, copyright owners being able to police for improper, illegal uses of their copyrighted work. Ultimately, that's a lot of what this comes down to. I don't think it's anybody's surprise to anybody in the room or anybody on the webcast that piracy is a huge problem for the content industry. If it wasn't such a significant problem, then maybe copyright owners would be a little bit more willing to sort of entertain different concepts here. But the fact remains is that, trusting somebody to delete their copy when they're, let's say you have an ebook and you want to give it to a friend, just like you did a hard copy today. But in order to do that, you have to delete the copy off of your computer. Trusting somebody to do that these days?
Or trust the user who even knows how to do that.
Yeah, yeah.
Yeah, exactly.
Yeah, or aware that they should be. Yes, exactly. That's a long way to go, especially given the problems, the piracy problems the content industry has. The copyright law is a balancing act, and so if you're going to take away with one hand, you should be giving with the other. And if the first sale doctrine is going to be changed and altered in some way, be it by the Supreme Court or be it by Congress, then something in terms of the anti-piracy tools that are afforded to copyright owners and the ability to prevent piracy or address piracy or combat piracy, something there would need to be done to sort of counter that, I think. Yes?
I have another question. This is for you, Dan. Given whether it's the Supreme Court or Congress starts evolving where we are today, what are publishers' options? You mentioned a few things that might be technical options for publishers to manage copyright use. What are the options today without being too draconian and keeping positive customer relations? And so that's kind of question part A. Question part B is, what would you like to see that you don't have in your toolkit today?
So the question is really, what are publishers doing today in terms of digital distribution and copying? I think there are many different tools that publishers can use. A lot of us, particularly those of us who license more in an institutional level, are able to monitor like password usage and that sort of thing, so we can see if someone's signing in under a password in one location and 2 hours later they're across the country where they couldn't be signing in with the same password. There are those kind of controls. I think publishers have generally taken the attitude toward their customers that they want to have a conversation. They want them to understand the importance of what they offer to the customers, what the restrictions are on usage, and I think it's true that over the last 10 years, particularly in digital publishing, the amount of allowance for usage has grown rather than shrunk. And really, I think from our experience at McGraw-Hill in terms of anti-piracy, we find that most people want to do the right thing. It's a matter of knowing whether they are doing the right thing, and part of that is our responsibility to educate them. But I think the difficulty is going to be, in this particular instance, in digital, that you can't rely on the customer knowing exactly what they should be doing. I don't think in terms of first sale and copying digital material and sending it along, that is what the problem is. It's usually inadvertent piracy or someone who intentionally knows that they're breaking the law. And it kind of goes on that spectrum, either unintentional to knowing exactly what you're doing and intentionally trying to break the law. I think the problem is going to be here that you're not going to know whether you're breaking the law or not. It's going to be much more difficult to track. You're going to have to find a way to prevent people from using your information strictly beyond the terms and conditions in your contract. So you may have to renegotiate contracts. You may have to figure out a new way to track and monitor, all of which makes it more cumbersome for the user to make use of material you really want to get in their hands, which then in effect lessens your bottom line. Because you're going to be selling less, people are going to be upset with you. And I think also from our experience, when you put too many fences around information, digital information in particular, then the customer just does whatever the customer wants to do because they feel so restricted that they just don't believe this is the right way to go. I think the danger coming out of the Kirtsaeng case is whatever the decision is made, and hopefully it's on behalf of publishers, which would be a good thing, it's going to raise the public awareness. And if the case comes down with a decision that says, in essence, the first sale doctrine does not apply, including to digital works, then you're going to have a whole rash of people out there who believe they can do whatever they want to with whatever they get on their desktop, whether it's at work or at home.
I mean, what it's going to do is, if the Kirtsaeng case comes out in favor of Dr. Kirtsaeng, you're going to see a lot of businesses have to take a step back and rejigger their business models, for lack of a better word. You'll see that they're relying a lot of these businesses in the copyright community, be it movie, music, content, software, video games, whatever the case may be, are relying on a certain backdrop, a certain foundation that the law provides. If that foundation changes, with them, the way they distribute their works, the way they market their works, the way they sell or license their works is going to change.
And I would say possibly the way they price their works.
Yeah.
And let's keep in mind, the issue here really is about segmenting overseas markets. You know, and again, as I stated a little bit earlier, a large reason, in addition to all the reasons that Keith gave about cultural sensitivities, requirements made by the nation in which you're trying to produce your work, it comes down to be able to sell the work in that market at a price that the market will sustain. And as we expand globally, and as we try to get our footprints into what are emerging markets today but will become large developed markets in the future, it's going to be very difficult for publishers to be able to price there at a very low price to get into that market and serve those customers and still have a guaranteed return here in their home country. So I think you may find pricing differentiations as well.
Yeah, and as I said at the outset, this may appear at first blush that, oh, this is just something that benefits the content industry or copyright community. But it's not. I mean, it certainly does, but it also helps consumers. Those nurses in Thailand that wanted to buy the textbooks that Kurtzing sold here in the United States couldn't get the textbooks because he was selling them here in the United States when they were meant for Thailand. If all of a sudden the law changes, so price differentiation, as Dan mentioned, isn't permitted or isn't enforceable, then all of a sudden you have to sell those books in Thailand at the same price that you're selling them here. Well, you're not going to sell nearly as many books in Thailand, so all of a sudden you're not selling as many books. What happens to the price in the United States? Well, that's going to go up probably. So the U.S. consumer is all of a sudden paying more money because you cannot dispense your costs over a wider market. Your market has shrunk. So this is bad for the publishing industry. It's bad for consumers. Hopefully the Supreme Court will recognize that. Let me just move on to very quickly mention one other licensing issue that really doesn't have to do with the first sale doctrine at all, but one that you should be at least somewhat aware of. I won't go into great detail, but there's a statute, a federal statute called the Computer Fraud and Abuse Act, the CFAA for short, that recently has come under fire. Now, this is an anti-hacking statute. That was its original purpose. It has over the years been broadened quite a bit, so now it applies also to access that is in excess of what is authorized. Well, how do you find out whether access is authorized or not? You look to the license agreement. And the license agreement says you can access doors A, B, and C, but not D, and you go through door D, guess what? You've exceeded your authorized access. Under the Computer Fraud and Abuse Act, today, although there's some case law, you know, that's sort of all over the map here, but as a general matter, you could use the CFAA to help enforce those licensing terms, depending on the specific factual scenario. Under the CFAA is both a criminal cause of action and a potential civil cause of action. Recently, this has all been brought to a head because the federal government pursued someone named Aaron Swartz, who headed up a group called Demand Progress, a group that is sort of known for being very anti-copyright. What Aaron Swartz did was he went and downloaded a bunch of journal articles, thousands, if not millions of journal articles, without authority. And the federal government went after him, and he was looking at jail time. I think the plea agreement was going to be somewhere in the range of nine months or something. It's not a significant, huge amount, but still. And what he did was, faced with paying his attorney's fees, jail time, he committed suicide. All of a sudden, this became a big issue in the newspaper at the beginning of this year, and people are calling now for the change in the CFAA. I mean, there'd been some legislation out there to potentially change the CFAA for a couple of years now, but now there's been a lot of pressure, and Congressman Zoe Lofgren, in fact, has drafted, not yet introduced, but drafted some legislation that would change it so that terms and conditions of a license agreement are not enforceable under the CFAA. Now, for those companies that really didn't look to the CFAA to help them out to enforce their contracts or terms and conditions, this may not be such a big deal. But it is a sort of a tool in the tool belt that copyright owners have to pursue those who are really not abiding by license agreements, just like the first sale doctrine. So what you've got is the potential loss of the first sale doctrine to help enforce your licenses, the potential loss of the CFAA, all of a sudden you find yourself in state court, bopping around from state to state trying to enforce your license. That's pretty difficult, especially in the environment we live in the internet, where everything is, certainly not even restricted to the United States. It's all global. You're trying to get customers throughout the globe. The idea of trying to enforce your licenses in each different state where the law is going to be different, some courts will be good and get it right, some courts won't, is pretty much ridiculous at this point. Anyway, so that's another licensing issue.
Yeah, and I think, important from that issue is for those of us who produce really data-rich content, and we'll get into some data stuff a little bit later as well. But, there's questionable protection for data in this country in terms of copyright law. You don't get full protection under copyright law if you just put out a bunch of facts. And we have always relied on our licenses, particularly since the digital stuff has come up, to enforce the ability to control the use of the data that we provide, since we can't always count on copyright law as the ultimate bulwark of law that protects our data. So the CFAA is particularly important for those companies that produce data-rich materials. It's also important for companies who have a lot of stuff on their web pages but have terms and conditions that restrict what the user of that page can do with the information they see. And that's another aspect of the CFAA language, exceeding authorized access or exceeding basically the terms and conditions that the user is able to see on that site. If this goes down the wrong way, I think we're going to find ourselves in a lot of, as Keith said, a lot of state courts trying to enforce licensing terms and agreements. They're not always uniform across all those states. We tried 15 years ago to get a uniform digital licensing law passed for the states, and the same people who are fighting the CFAA language today stalled us on that effort, so we don't have a uniform law that protects licenses at the state level or makes clear what licenses can and cannot do. I think good news is SIA is on top of this issue. We have spoken both, from SIA staff, but also with members and several people in Congress, in the administration. They're aware of the potential problems that arise here. I think they're willing to work with us on a solution, but I do think this is something that will be coming up again in the next Congress. So this year, next year, look to see what happens.
Okay, so why don't we move on to the third issue in the next big battleground for the copyright community.
So, back to basics. What copyright does for content owners is give you basic rights that you can control. For example, the right to distribute, the right to display on a computer screen, the right to control further uses of your work that could not be created were it not for your work itself. That's referred to in copyright lingo as the Berne three-step test. And the Berne three-step test, basically, Berne is Berne Convention. It's the major copyright treaty in the world. It's been around since the mid-1800s. And what it says is that you can create exceptions to copyright, but those exceptions can't go so far as to hamper your ability to exploit your market. In other words, to make money off of what you're putting out in the marketplace. So that's really where this battle is being joined most recently, on whether some of these exceptions should be put into either international law or U.S. law or foreign laws of some kind, and whether through their operation they will not be so broad as to prevent the ability of the copyright owner or the publisher or the content provider to continue to market that out into those customers and continue to make money off of it. So the one we're going to talk about that is kind of a hot topic at the moment is the case of Meltwater versus AP. And I will rely on my very astute lawyer, legal expert here to give you the facts of the case if I mess them up. But in essence, Meltwater is a web scraping service that goes out and gathers stories from all over the place and then republishes them, sometimes in a customized format for certain customers who want to know who's been writing stories about me. Sometimes they just make it widely available, all this information. And what they did was go off and start scraping AP stories, and rather than just putting what you would see, for example, in a Google search, which is, you know, the title, the story, and the lead sentence, they were reproducing the entire article and selling it. They got sued by AP for violation of copyright. They objected. This is now before the courts. And their argument is that since they were simply scraping web pages, it's quote-unquote publicly available information, something that's often confused in these debates about whether the information is made public with no restrictions or whether the information is public information, published information that's publicly available, I should say. They claim this was published information that was publicly available, no restrictions, even though AP had its terms and conditions on its website. The case is now in the First Circuit, right? I mean, Second Circuit.
Second Circuit.
It's about to go into the appeals level?
No, they have not
they're still
heard
at
the case. They've
okay,
not
so they haven't
decided
heard the case yet. So this will be a critical case. Past decisions have found that that kind of wholesale copying and reproduction is not allowable under copyright law. Probably even in terms of news, particularly not allowable under misappropriation law as well. But it's going to be an important decision that comes out of the Second Circuit. I'm sure it'll be appealed by either side that doesn't win. But it will eventually settle, we hope, the idea of whether you can go to a web page, just scrape that web page, use the information there even for a commercial purpose without any kind of revenue going back to the original content provider or without any kind of restrictions on what you could do with that information further once you get off the web page. Is there anything else on Meltwater?
Yeah, well, I was just going to say, I mean, Meltwater, the big issue is fair use. Meltwater is saying what they are doing is a fair use. That the AP articles are up on the internet. Anything up on the internet is fair game. They're allowed to copy it and do what they want with it. Gee, can you imagine if that were to be the law? That's a pretty scary thought. Talk about giving an incentive for copyright owners to put everything behind firewalls. Well, that's what everyone would have to do if that were to be the law. But that's what Meltwater is saying. Meltwater, one of the Meltwater argument is that if you don't want us copying your content, then you need to use a meta tag, you know, no bots.txt header, which basically tells a web scraper not to copy that information. If you do that, maybe they would abide by that, okay? But if you don't do that, well, then everything's fair game. They're allowed to copy your content and use it as they see fit. That is obviously very, very problematic. They say what they are doing is what's called a transformative use. It's a type of fair use. They are saying what they're doing is yes, they're taking the articles, but they're not taking the whole articles. There's some debate factually about that, whether they're taking the whole articles or how much of the articles they're taking, so we won't get into that. But what they're saying is they're taking the articles and using them for an entirely different purpose, okay? But if you look, at least look on the record, everything between the court documents, if you go to Meltwater's site, it says, you know, go, sign up for our service to avoid copyright licensing. Read our articles so you don't have to go and, to the Associated Press or the New York Times or wherever to read their article. Clearly, in my mind at least, what Meltwater is attempting to do here is to usurp the market of the Associated Press, and that is not a fair use, okay? And that's really what's going to come out here, is if you usurp the market for something, it is not a transformative use. Transformative use is taking something, putting it into entirely different use that the copyright owner never conceived of. It wasn't a potential market for the copyright owner. It wasn't an actual market for the copyright owner. It's something entirely different and really doesn't adversely affect the copyright owner at all. That's really what's going to come down at issue in this case.
So if Meltwater agrees with the case, then he won't need any copyright clearance because they're all time before it has
Yeah, so the question was, if Meltwater were to win, there'd be no reason for a CCC, a Copyright Clearing Center, or any sort of collecting society or representing copyright owners, yeah, any agency. And, that certainly would, I don't want to go that far, but that would certainly be a concern. Why would you need to get permission if the law allows you, as long as you can get your hands on something, to go ahead and use it for these purposes. So now Meltwater is claiming to be a search engine. That's frankly just a label, is all it is. Search engines, to my mind, go ahead and scrape the entire internet and then provide links to the original content. That's not what Meltwater is doing. They are providing the content. They're also not scraping the entire internet. They're scraping specific portions, just like the Associated Press and other news reporting agencies, and that's it. They are very different than a search engine. This is what we would call media monitoring service, like an old clipping service. And if you look at the clipping services like Burrell's News, like Cision, and look at other data aggregators like a Factiva, LexisNexis, and what have you, they license this from Associated Press. They license other content communities, from other content companies. Why should these good actors be penalized by someone who's breaking the rules? It would be a bad precedent to set.
And as we talk about fair use, I think it's always helpful to remind content providers that we also take advantage of fair use provisions ourselves. So it's a balance here that we're trying to strike. But I think the concern that we have is this balance is going way over to the side of users in some cases, as opposed to trying to understand, as Keith was explaining, by having fair use that is a balanced system of laws and court decisions, it allows information providers like McGraw-Hill and many of the companies that are listening in today to provide information at no cost in certain kinds of slices and dices, whether you want to do it on a web page, whether you want to do it as an enticement to future subscribers, et cetera, et cetera. But we also know that there are limits on what you can do with that. Again, the ultimate limitation is you can't take so much or do so much with my work without my authority that I have no market to put my stuff back out into and gain revenue to create new products and services. And that's really one of the problems we have in Canada. But first, I'm going to go to the HathiTrust. The HathiTrust is a issue that's now arisen. These are libraries whose books were scanned by Google for Google's book project. And when Google went in and scanned these libraries' works, one of the things that they agreed was they would provide these libraries with a digital copy of everything that they had scanned. These libraries have now joined together in a consortium. University of Michigan is kind of the leader in this, but there are, I think, 5 or 6 libraries involved in this project. And what they have done is take the scans that they received back from Google and have created a digital library accessible to the world. And this case has been before the courts. And the content owners are saying that this is not a fair use. The argument coming from the other side is this is a fair use. In fact, it's a transformative use of the work because we digitized something that was only available in hard copy. And this gets into kind of the nitty-gritty, ugly nitty-gritty of the copyright law. As Keith was explaining, and normally, we think of transforming a work as something completely different for a purpose for which it wasn't intended originally. Now, these are books that sat in libraries. They're simply taking the scanned copy and producing another library. So it's not really a transformation. All it is a digitization of the work, right? This case was before a circuit court here in New York. The judge found in favor of HathiTrust that it was a fair use, a transformative use. He also went further and said that one of the benefits from these scanned copies was that it would be able to allow access to these works to the visually impaired because of some of the technologies that could be associated with the digital copies. That raises a whole other panoply of problems under the copyright law because there is a section in the copyright law in the United States that says for the reading disabled, authorized entities under the law, and they have to be authorized entities, and they don't, by the way, include college and university libraries as an authorized entity. They have the right to obtain a copy of a copyrighted work and then transform that work into a work that's easily accessible to the reading disabled. Originally the blind, but it's also been extended to things like dyslexia, just poor vision, et cetera, et cetera. So what the judge in the Second Circuit did at the district level was say, it's okay for HathiTrust to do what it's done. It can go ahead and display. And in fact, there's an additional benefit to society here because they're making works available in a digital format, much like the Congress intended in this exception to copyright law for the reading disabled. This is now going before before a three-panel judge at the Second Circuit Appeals level. SIA has submitted comments in a brief. Many publishers have submitted comments in a brief. But this is being looked at as a major case in terms of what libraries in particular are able to do in terms of digitizing works and making digital works generally available to the public. So this will be a big one, and if it comes down on the wrong side, even though most of us are moving out of print into digital, born digital works, there's still a lot of print that we produce. A lot of that will stay print copies for various reasons, maybe because that's what the customer wants, maybe it's because it's easier to get to the customer in that format. And if libraries are suddenly given the right to take every single thing that they bring into their subscription-based services and make a digital copy and then offer it back to the general population, then you're going to have a lot of problems in selling print products out in the marketplace these days.
Did the judge throw out the 201C compliance as well? That's the requirement that if you're digitizing a whole work, if you're going to present a part of it, you must present it within the context of the whole work.
No, I don't think that was even raised in that case because what they're doing is presenting whole works. They're presenting whole works.
Present a whole work.
Yeah, so it's all the books that they had on their shelves. They just had them scanned, and now they have the digital copies. Okay.
Well, let me just
Yeah.
mention, I mean, this is, we've mentioned a couple cases here. This is part of the sort of the anti-copyright faction, their goal to really try to expand fair use. We've seen it happen over, cases over the years. It used to be, if you were to look back at the fair use doctrine 20 years ago, it was this big, and now you look at it and it's this big, and there's a continued push to make it this big. And that's a big concern, because if fair use gets this big, copyright owners' rights shrink down to that big. And that's obviously a big problem. But not, fair use is unique to the United States. We have fair use, but outside the United States, they have other doctrines that's somewhat similar to, like, for instance, Canada, they have fair dealing. So I'll throw things over to
Right.
Dan to talk a little bit about Canada, and then we'll move on.
So in Canada, back in 1998, the United States passed the Digital Millennium Copyright Act. That's the DMCA you all heard about. It set up the notice and takedown regimen for getting ISPs to help copyright owners in removing infringing works that are present on their networks. Canada took 15 years to pass its version of the DMCA, and publishers both in Canada and who sell into Canada, content providers of all kinds, were very encouraging to the Canadians to get this done, very much looking forward to it. The good news is that Canada last year passed its version of the Digital Millennium Copyright Act. There are several pieces of bad news in that legislation. The first piece of bad news in terms of the DMCA kind of notice and takedown is that in Canada, ISPs are not required to take down infringing materials on their networks once it's been identified as infringing. Rather, they are only required to give a notice to the user. So rather than having a notice and takedown system, they have what's called a notice and notice system. In essence, there is no threat of potential prosecution against the user and no threat of liability to the ISP for having a system that fosters infringement, which is the whole basis of the notice and takedown system in the United States. The best a copyright owner can hope for in Canada is that the ISP will continue to send notices to the user, and the user will finally pay attention and say, oh, I'll stop doing this activity.
That's a good joke.
Yeah.
Yeah.
Yeah, that's the point. But there were two other things that were done in that law that are particularly disturbing to almost any content owner. The first is a very broad exception. So as Keith said, they don't call it fair use in Canada, they call it fair dealing. Same term they use in the United Kingdom. They now have, under fair dealing, a broad exception for uses of any content in education, for purposes of education. It's not educational materials that are designed for the education market. It's anything that anyone in education doing an educational activity wants to use. You have to obtain the copy legally, but once you obtain that copy, and there is no restriction under Canadian law for this education activity or research activity to be totally nonprofit. So it could be, for example, a worker retraining program in a company. It could be some sort of, cultural enhancement program that a private organization is offering. Once you have a copy of that work, you are free to make multiple copies of the work, to redistribute the work, everything you want to do within an educational context without the authority of the copyright owner. An example that's already occurring in Canada and in terms of the education publishing marketplace, Canada has a different system for licensing for sales into the education marketplace, K through 12 particularly, but also higher education. So rather than, let's say, a McGraw-Hill education publisher sending a sales rep into an institution saying, this is what I'd like to sell you, let's sign a contract, you go in and say, this is like what I'd like to sell you. You don't sell a contract into the education institution. Rather, you go to something called Access Copyright, which is the national licensing body for Canada. Schools pay into the national licensing body. The publishers get reimbursed through that body. K through 12 licenses run, I think, for 2 or 3 years generally in Canada. It's my understanding. They're about to come up for renewal, and already we're seeing K through 12 schools saying, we're simply not going to license anymore. We don't need to. We'll just go out and get a copy, and then we'll just use that copy for all the purposes that we need within our school systems. Keep in mind, it's not simply educational materials. As I've mentioned several times in the past few weeks in conversations about this, even McGraw-Hill information. So things that come out of our S&P ratings, our S&P IQ, that are business school oriented. They're used in business schools. We have a construction division. We have an aviation division. So architectural schools, avionics schools. All of these materials, as long as it's used under the context of education, and again, both nonprofit and for-profit, can be used without restriction in Canada. The Canadians dispute that, but the Canadians are also failing to explain this new exception in terms of rules and regulations to make it clear to both the user and the provider what kind of restrictions are going to be put around a very broad-based education use.
Are there efforts for the Canadians to provide clarity around that?
We've been talking to them, both Canadian publishers and U.S. publishers who serve that market, and a lot of U.S. published material goes into that market, and it's up to this point in time they have failed to do so. Very briefly, the other thing that happened in Canadian law is a new exception for user-generated content. Now, this was designed to take care of the problem that we've heard of, think about YouTube, mashups. That's what they were trying to do. Allowing individuals take a piece of a song, take a piece of a TV program or a movie, and do something clever with it and post it up on YouTube. So they created an exception for user-generated content. Again, there are no real definitions about what this all means, but it's written very broadly. In essence, it says, I as a user can obtain a copy of a work legally. So let's say I did it in the education context. Make even minimal changes to that work, maybe add some commentary, maybe add a new chapter, maybe add some additional material, factual material into that work, then that work becomes my work. Even though I may have only made minimal changes to it, not only does it become my work, but I can distribute that work out into the marketplace. The only thing I can't do is directly charge for that work. However, I could post it on a website with advertising revenue. And suddenly it becomes my work, even though I may have done no more than put an introduction into a book that already existed. So you can see the potential problems here. And that's one of the difficulties we have with fair use and these broad exceptions that are being created. Not only does this burn three-step test about don't make them so broad that they could destroy the market for the publisher, doesn't seem to be in consideration, but in trying to solve a particular problem, like how can users really do mashups without running afoul of copyright law, then you create a broad exception that implicates all other kinds of content that maybe wasn't your intent, which is why we would like the Canadians to begin to explain what their intent was and maybe clarify exactly how far you can go in these kinds of in these kinds of fair use exceptions they're creating. But it's, as Keith said, you know, we saw the fair use provisions in U.S. copyright go from here to here. Now they want to take them to here, and eventually they'll be here. And when that happens, then the fundamental rights that are under that Byrne three-step test basically disappear. And so that's why we're very much concerned about these things.
Okay, so we have about 5 minutes or
To
so,
go to
so we
one
can
more
leave. So
thing.
we can leave.
Yeah.
Yeah, five
Yeah.
minutes of questions. So we'll go through the last two topics, I think, relatively quickly.
Very
so,
quickly. So, in the EU, they're undergoing a process to talk about starting changes to copyright law, not this year, but next year. It's called a consultation. One of the things that appeared in their consultation, again, this goes back to the idea of creating fair use exceptions for certain purposes, was the notion of creating an exception for data mining. The idea here is that researchers in the academic community want to be able to go through textbooks or history books or statistical books or even trade publications and mine them for patterns. We were talking earlier, for example, someone's going through a bunch of books to try and figure out when the concept of the United States became a popular concept in the United States. And they're doing it by going through old textbooks in elementary, higher education, in articles and publications written by the government or about the government to see where this kind of change made. Very worthy topic, very worthy exercise, and could bring a lot of insight into the changes in American culture. That's data mining, in essence. And it doesn't really harm the publisher of the work. That wasn't why that work was published. But when you get into data-rich content, like we at McGraw-Hill provide, and a lot of other companies provide these days, and that customers are demanding more and more data to be integrated within their system, and then you have the idea of creating an exception for data mining, this is where we have to start questioning what the EU really is intending to do. Again, a narrow exception to do certain purposes probably isn't going to be harmful, but we need to have better clarification, better explanation so that these things don't get so far out of hand that data-rich products and services are suddenly open to data mining, which is the entire purpose of that work to begin with. So that's one of the things we're kind of worried about in terms of the EU. And again, companies are on both sides of this. We at McGraw-Hill do data mining. A lot of companies do data mining. But we also have a lot of data that we don't necessarily want everybody to mine without certain restrictions about what they can do with that information.
And for publishers who are on the call, many are really exploring data and big data, which is the phrase right now. As they explore analytics, meta information, and other information that's buried within their existing content, how should they really be thinking about their copyright of this add-on information for data?
Well, I mean, data, big data, so, very, very quickly, let's not confuse what I'm talking about in terms of data mining of factual information that's, aggregated, produced, supplied by an information provider, as opposed to data that you gather about your customers, because they're really kind of two separate issues. A lot of people, when they talk about big data, are talking about customer data. In this instance, we're talking about data that we provide as part of a content product. Most of that is done in digital format today, and I think this is where we have to go back and look at our licensing terms and conditions. I know we at McGraw-Hill, as our customers have begun to demand more and more just pure data feeds without our editorial attached to it, we've re-looked at those contracts. And we put certain kinds of restrictions on what they can do in order to meet the needs that they need to have met. Because a lot of these people, especially when you get into the financial markets, are looking to integrate that data into their own systems for purposes of analysis, comparison, and decision making. And that's a perfectly legitimate need, a perfectly legitimate use, but it does have to be restricted at least to the point where it's okay for you to take our data and incorporate it within your own work product. It's another thing when you take that data, incorporate it into a work product that you're going to go then sell against us in the marketplace. Or sell in a marketplace that's going to harm our ability to create perhaps a derivative product off of that that we were intending to do anyway. And I think, so for data providers, I think you really need to kind of consider what the customers are looking to do, and you need to kind of in your own mind, after your conversation with the customers, make the determination, where does that stop? You're allowed to do X, Y, and Z, but you're not allowed to do X1, Y1, Z1. You know, that's where you have to kind of, and it will evolve, and, you know, as more data demand comes, you know, the other thing that I'm sure will happen in the industry is that pricing will change as well. You know, depending on what you're looking for and what you want to do with it. That's the whole purpose of a license. It allows you to negotiate with the customer on best terms and conditions to the benefit of both the provider and the user. And that's why, going back to our earlier conversation, these licensing things that are going on are also very worrisome, especially for digital publishers these days.
Okay, so in the interest of time, let's go to the last topic, which isn't last because it's not important. It's actually very, very important. It's just a little different than the other topics we've talked about. This is about brand protection. And for those of you who don't know, well, right now there's 20 what's called top-level domain names, things like .com, .net, .org, .gov, .edu. Those are all top-level domain names, or TLDs for short. There's a group called ICANN, stands for the Internet Corporation for Assigned Names and Numbers. And ICANN, for the past several years, many, many years, has been exploring this process or program for exponentially increasing the number of top-level domain names, or TLDs, from the existing 20. So instead of 20 TLDs, we may have 2,000 or 200, or we just don't know at this point. We anticipate that the first new TLDs will go live this fall. So for this fall, that means you might see a .book, you might see a .lol, you might see a .movie, who knows? Okay, but that'll happen this fall. And when that happens, okay, those TLDs will start beginning to accept what's called second-level domain names. So for instance, in the URL www.siia.net, the .net is the top-level domain name. The second-level domain name is the SIA part. That's our trademark. We hope no one else takes SIA.movie or .book or whatever the case may be, and your company should be worried about the same thing, because anybody could come along, potentially, under this new system and grab up your trademark and use it on a new TLD. Cyber squatting exists today. It certainly could exist in the future. So why am I telling you all this? Why do you need to know? Do you need to act immediately? The answer to that is yes, because the deadline coming up on March 26th. On March 26th, ICANN begins accepting registrations for what's called the Trademark Clearinghouse. There are trademark protections that are put in place to protect you, but none of them are any good unless you register your trademarks with this Trademark Clearinghouse. The first day to do that is March 26th, okay? And what it is basically a big database of people's trademarks, and then there are various trademark protection mechanisms I don't have the time to go into now. If you want, you can email me at keithk@sia.net, and I'll be happy to provide you more information. But there are mechanisms to protect your rights in your trademark. Like I said, they're no good unless you register your trademark with this Trademark Clearinghouse. First day to do it is March 26th. You'll have weeks after that before certainly any of these new TLDs go live.
Is there a cost associated with registering your trademark?
I have to double check. The question was, is there a cost associated with this? I think actually there may be, but the cost is not, I don't think it's that significant. I do have to double check that because they've gone back and forth on that issue, so I'm not sure where that has stopped. So, so let me throw things over to, I guess, if there's questions, if we have time, Kathy?
I've been asking questions as they've been coming
Okay.
in. My only thing that I saw is, I noticed that already some people are challenging, so the book
The
dot
book,
with
yeah.
Amazon is
Yes.
is a great example of a group challenging Amazon purchasing that.
The question was, look, they've already heard that somebody's challenging .book. Actually, there's a deadline of, today's the 12th, right? Tomorrow, I believe the deadline is March 13th to challenge particular TLDs that have been applied for. You can go to ICANN's website if you want to find out what's been applied for. And .book in particular is being challenged. The reason .book is being challenged is because it's been applied for, at least by Amazon, as being a closed registry. In other words, nobody else would be able to get a second level domain name. Anyone else would be able to do anything on .book other than Amazon. So people are protesting because they believe, among other things, it's a potential antitrust violation. So that's different than copyright or trademark concerns.
Yeah, but I think in terms of the brand, it's very
Yes.
important, right? Because if you have, like, instead of a .com, you would have a .book, then as a second level domain, you could have a McGraw-Hill.book, you could have a Pearson.book, you could have whatever .book. So if people are going to be looking for books in the future as the internet evolves into this new system for domain names, then you would like to be able to have your brand associated as a second level with a .book.
Anything else? Well, I'd like to thank Dan and Keith. Thank you very much. This is, again, Kathy Greenler Sexton wrapping things up here. On your screen are some upcoming events for webinars and in-person events. We also have some conferences that you can also research at siia.net. And if you have any comments or suggestions, here is my information. We've very much enjoyed putting this on today. There's a tremendous number of people on the webcast, which is actually very exciting for us. And if you liked this format, let me know. If you have any suggestions for other questions that you didn't get answered today, let me know. Other topics you would like us to get covered, let me know. We are here to serve you, our members in the industry. Thank you once again for joining us today, and have a great day.
Thank you.
Thanks.